Welcome to meeting number 14 of the House of Commons Standing Committee on National Defence. Today, pursuant to motion adopted on October 23, 2025, the committee is meeting to resume its consideration of Bill C-11, an act to amend the National Defence Act and other acts. Today's meeting is taking place in hybrid format. Before we begin and continue, I ask participants to consult the guidelines on the table. These measures are to help prevent audio and feedback incidences and to protect the health and safety of the interpreters. I would like to remind the witnesses and members to please wait until I recognize you by name before speaking. If you wish to speak, please raise your hand. And for those on Zoom, please use the hand raise function. The clerk and I will manage a speaking order as best we can. For language interpretation, please use the earpiece and select the desired channel on your in front of you. And for those on Zoom, select the appropriate channel on the screen for either floor, English, or French. We appreciate your patience and understanding. Before we welcome our witnesses, please note that we may be discussing uncomfortable experiences related to sexual misconduct. This may trigger sensitivities and distress. We recognize that these are difficult discussions, and I'm sure we will all be compassionate in our conversations and questions. If you need help, please advise the clerk. I'd now like to welcome our witnesses. Elvira, I'm going to have a tough time with your last name, so bear with me. Yazbarenyi, a retired corporal. Paula McDonald, Heather Vanderveer, and Rachel Smith, founder and host of the Silenced Voices MST. I'll now invite Ms. Yazbarenyi to make your opening statement. You have up to 5 minutes.
Thank you, Chair. Thank you for inviting me. I'm not supported by any groups nor political. I was proud to serve my country as a 50-plus-year-old soldier, but my rape case with forcible confinement in a broom closet on base was botched. The government's obligation is to protect citizens from harm and is the basis of criminal law. My assailant was under investigation for a previous essay, bad conduct, and a known predator to NIS. I was also infected with an incurable STD, but NIS ignored his admission and tampered with evidence. My case was dropped after 4 months, told not to call MPs as I was stalked and exposed on social media and pressured to accept a redacted version of my file. When I handed a lawyer's letter, COC blamed my own delay. My assailant was charged for his first victim 2 years later for his conduct, but DOJ is trying to redact her from file. My ATIPs are being withheld, but past ones show gossip by COC as retaliation continued after my transfer, resulting in injury. As a weapons tech, I held 9 unrelated jobs. Padres, COC, and mental health said, take the victim tag off, as I endured retribution in order to return to where the rape occurred, as doctors asked info on my case or prescribed unneeded medications. After switching to intelligence, my career was held back. While under trauma and health issues, I was ordered back to work. COC, wellness checks, and calls now increased. My private prosecution was taken by the Crown, but actus reus and mens rea were overlooked along with evidence. VWAP and ILA coupons were insufficient and demeaning. CAF, our justice system, and our government's handling of crimes and preventing harm is lax. Hockey Canada, NIGARD, etc. have angered the public. Insufficient evidence given to MPCC labeled my case a shoddy investigation, baffled why the accused wasn't charged. I was wrongfully released, CAF signing on my behalf. My application to VAC was lost. My support, Steve Torino, was threatened legally, and they threatened to come to my residence and pressured me for info. He urged government members with little response. VAC distorted my application, requesting my medical info, ignoring my IRB is enough. My human rights lawyer also turned on me with JAG, threatening AWOL. I reported a crime but suffered consequences for protecting myself and others. Culture change and gender issues are a mask. Gatekeepers who silence victims, crimes, and speak on our behalf must be removed. CAF must screen soldiers properly as they reviewed my assailant speaking Russian in our combats about CAF on YouTube, aka Russian spy guys. Facebook sexualized political posts were ignored. General Iyer wrote, "He's only informing Russians." This ridicules my country and our military. Why did Canada's former spy, who advised you on safety tied to CSIS and RCMP, get involved in my case and say to record and take pictures? Someone linked to a group that appeared before you said to claim suicide to get money. I was ordered to report in combats while ill, write memos, call 1-800 numbers. CO offered me to sit with my assailant or call if he shows up, were diversions. CAF used NIS and DOJ in court to follow my story. As victims in suicide increase, the system will crumble if you don't act. As a single-income person fighting for my rights and safety, paying lawyers with no results, my assailant is still working on base. CAF employed a known predator and placed him on course while under investigation. Is clear we are not protected from harm or our enemies. With Bill C-11, we must implement the previous justice's recommendations. However, the military, justice system, and police shouldn't overlap. Victims should have the same rights as the accused to balance the safety of our country and be accountable. Bring back loyalty and integrity to our country and give justice and restitution. Not just to those who were wrongfully accused, but the many victims who have been silenced, and prevent these crimes which were not in the gray zone. Thank you.
Thank you. Ms. Gallant, I'm sorry, no, we have other speakers. Ms. McDonald? Oh.
My name is Paula McDonald, and I was a master's educated social worker who served in the Canadian Armed Forces between 2014 to 2016 in both the reserves and regular force. My service was marked by gender discrimination and escalating gender-based violence that ended in retaliatory sexual assault. I'm not talking about workplace conflict. I'm talking about what happens when the chain of command uses powers of the state to control, minimize, and bury sexual misconduct inside the Canadian Armed Forces. It's the CAF sexualized culture made inappropriate comments and jokes and unwanted touching seemed normal. People in positions of rank use the atmosphere as a tool of control, treating subordinates as objects instead of human beings or soldiers worthy of respect. The CAF is not a private employer. My commanders, harassment advisors, assisting officers, and the military police were all exercising public authority under the National Defense Act. They controlled my work, my medical file, my career, my release, and my access to complaints. They also influenced how military and civilian police handled my allegations. When they acted as agents of the state. This means the Canadian Charter of Rights and Freedoms applies. When I reported sexual harassment and later sexual assaults, my allegations should have been taken seriously. I should have been kept safe and given access to independent, impartial investigations. Instead, everything stayed inside the chain of command. My harassment complaint and grievance threatened to expose senior medical officers that had violated the rights of a social worker who named the hostile culture. Protecting themselves in the institution came first. My complaints were rooted through chain of command-led investigations and internal processes. Harassment advisors and grievance officers reported to the same leaders I was complaining about. Military police opened files, spoke only to my supervisors, and then closed the files without ever interviewing me. When I went to the civilian police, I was told more than once to go back to the military system that failed me. At the same time, my leaders reframed my complaints. Instead of naming sexual harassment and abuse of power that led to sexual assault, they called me emotional, hypersensitive, and a mental health problem. They used medical referrals, medical employment limitations, and threats of discipline under the National Defense Act, including threats of dishonorable discharge, charge to pressure and punish me for speaking up. My harassment case became a disciplinary and medical case against me, not against those who engaged and created the hostile sexual environment. From a charter perspective, this matters. Section 15, Equality of Rights. As a woman reporting sexual harassment and sexual assault, I did not receive equal protection or equal benefit of the law. My experiences were minimized, my credibility was attacked, and supposedly neutral tools, medical labels, career limitations, and administrative measures were weaponized against me. This is sex discrimination. Section 7. Liberty and security of the person. The chain of command knew about escalating sexual behavior, threatened to misuse legal powers, and allowed a senior commander to gain power over my future in exchange for sexual access. This caused serious ongoing harm to my psychological security. This is state-driven exposure to risk and abuse of process. Section B, freedom of expression. Every time I used my voice, complaining internally, going to the police, or speaking to oversight bodies, I faced reprisal. I was labeled as disruptive, threatened with discharge, buried in pointless tasks, and ultimately pushed into a so-called voluntary release just to escape their abuse. The release freed the chain of command from having to answer for its membership's violence and violations to the National Defense Act. Chain of command-led investigations are not neutral when members of the chain of the command themselves are implicated. The military provost's office is not independent from the chief of defense staff or the broader command structure. In my case, the Canadian Armed Forces didn't simply mishandle a file. It used the machinery of the military justice and grievance system to protect its membership that violated the National Defense Act and silence me. The misuse of state power that the Charter is meant to guard against is what they did. And it is exactly what the reforms like Bill C-11 and a real shift to independent civilian jurisdiction over sexual offenses is so urgently needed to maintain the rule of law within the Canadian Armed Forces.
Thank you. Ms. Van der Veer, you have 5 minutes.
Honorable members, I thank you for hearing me today. My name is Heather Van der Veer. I am a veteran. I work with survivors of military sexual trauma, harassment, coercion, and abuse, people whose lives have been altered not only by what was done to them, but what the system failed to do afterwards. I'm here today because Bill C-11, as drafted, does not protect survivors. It risks harming them further. Every week, I work with people who have reported assaults and waited months, sometimes years, for an update. I watch their files get passed between military police and civilian police like an unwanted parcel, being told to start over because jurisdiction is unclear. Their credibility questioned more often than the conduct of the accused, and abandoned by institutions that promise to protect them. The trauma does not stop. At the assault, it continues every time the system avoids responsibility. Survivors call this institutional betrayal. I call it predatory jurisdictional behavior because avoidance like this is never passive. It protects institutions, not survivors. Civilian judges and Crown prosecutors are rarely trained in rank and power dynamics, coercion tied to postings and deployments, the impossibility of avoiding an abuser in a military environment, delayed reporting by retaliation and career threats, or the structural pressures unique to military life. These gaps shape outcomes. Civilian sexual assault conviction rates in Canada are already extremely low. When military complexity is added, the outcomes worsen. Survivors are not being transferred to a stronger system. They are being transferred to a system unprepared to receive them. The CAF believes they are modernizing through Bill C-11, but their definition of modernization is administrative, not survivor-centered. New oversight bodies may look modern on paper, but without enforceable responsibility, it isn't modernization. Shifting cases to civilian courts without preparing those courts is not modernization. Adding new steps and new handoff points does not bring clarity. Let me be blunt. If no one is required to act, the system never learns. It has to, which means this isn't random. When the law doesn't assign responsibility, The system doesn't step forward, it steps back. And the longer that it persists, the more the system learns to protect itself instead of the survivor. As written, C11 creates more steps, more handoffs, and more opportunities for avoidance, yet does not identify who must take care of the case. Instead of providing clarity, it gives institutions more places to send a survivor rather than to help them, more doors to knock on, more forms to submit, more timelines to wait through. Survivors cannot endure another round of bureaucratic ping pong. Right now, survivors navigate a maze. C11 adds more hallways, more locked doors. Every unanswered email, transfer, and not our jurisdiction sends the message: you are not worth the effort, your case is not worth the risk, your trauma is too inconvenient. A major review, Deschamps, Abor, Fish, the Ombudsman, the Auditor General, and class action findings say the same thing. Survivors are falling through the cracks because no one is accountable. C11 doesn't fix that, it reorganizes the cracks. True modernization requires accountability, clarity, and survivor-centered outcomes. Bill C11 delivers none of these. The greatest harm is not only when cases are dropped, but when they sit in procedural limbo, and that is cruel in its own right. Closure means certainty, dignity, the ability to heal, and knowing that your life matters as much as the institution that failed you. Bill C11, as drafted, risks denying survivors closure. Survivors are not asking for special treatment. They're asking for the bare minimum any justice system should provide: a clear process, a responsible authority, a real pathway to resolution. If Bill C11 cannot guarantee these three things, it will re-traumatize survivors, deepen mistrust, and reinforce the failures that brought us here. Thank you.
Thank you. Ms. Smith, you have 5 minutes.
Thank you for having me and the invitation to appear today. I'm a former United States Air Force officer and a survivor of military sexual assault. My experiences are not unique. The way the system responded to what happened shaped the course of my service and my life. And the patterns I experienced appear across many survivor accounts with whom I work today. When I arrived at my first duty station, women who had served there before me offered quiet warnings about safety. 2 weeks later, I was assaulted. I did not report the full incident, yet retaliation still followed. That experience made it clear that the system in place did not protect me and did not truly have a safe or independent way to come forward. This pattern has been identified by many service members and veterans who describe an environment where the chain of command controlled both their daily lives and the response to their assaults. Through my work with survivors, the same issues come up again and again. So many describe being exposed to further harm by reporting pathways created by military leaders. There are descriptions of support systems that did not operate independently from the very structures they feared, and of long-term consequences for their health, careers, and ultimately their ability to continue serving. These accounts come from individuals across different branches, ranks, and backgrounds, reflecting structural weaknesses rather than isolated failures. When independent investigation and external oversight are missing, predictable and well-known outcomes follow. Units lose trust in their leaders, survivors avoid reporting while offenders remain in authority, and the ripple effect touches readiness, retention, and national security. Upon reading Bill C11, I believe measures in it outline and address the core weaknesses that shape whether service members trust the system that governs them: independent investigative authority, external judicial oversight, and protected support mechanisms for victims create conditions where they can ask for help and report without fear of retaliation or compromised processes. These measures also help restore confidence in the institution as a whole. Across the survivor accounts I encounter, one point comes up consistently: the harm does not end with the sexual assault. It's the way the institution responds that has deeper and more lasting effects. A military force cannot be effective when its members doubt the fairness, independence, or safety of the structures that are intended to protect them. Accountability requires clear processes, credible oversight, and reliable support. Strengthening these areas protects survivors and then strengthens the institutions themselves. Thank you for your time.
Thank you to all four of you for your opening remarks. And we appreciate you being here, and we appreciate your courage and transparency and giving us and enlightening us in terms of the issues. What we're going forward with in this bill and what we want to do is, as a committee, is to ensure that we protect the rights of our victims and those that justice prevails. We're going to start our first round with Ms. Gallant. You have 6 minutes.
Ms. Jasperini, to whom did you first report the incident?
Thank you for your question, Chair. If you just give me a second. At first, when I reported, I felt, hold on, just. Can't find it.
Rini, it was.
Sorry.
It doesn't. I don't need the name, but was it your commanding officer?
Yes.
What was the relationship?
Yes, I have it written down, condensed. So I called my COC because I was distressed. They called the MPs to check on me. The COC ordered me to speak with them. Then they called an MP who drove me to NIS, but they said I could leave at any time, which, anyway, years later, it looked like it was a police training exercise in Borden. Reporting a crime was one thing, but COC, NIS, lawyers, and gatekeepers in place took this to another level. Each person who tampered, gave away info, interfered, are responsible for their actions.
Okay, I'm going to ask you questions in a certain order so I can get a clear picture of what happened. So, were you on your own base, or were you off training at that time? Where did this occur?
I was on base, yes.
You were on your base.
I was, yes.
Okay. So were you given the choice of dealing with the OPP versus the military police?
I had communications with OPP. I tried every possible avenue, and they said that it was not in their purview to help me. So.
Okay, did you ask, when you were with the military, did you ask them to be in charge of it instead of the military? Did you ask the CAF?
To be honest, I was still processing everything.
Okay,
and
so you didn't ask the people, the MPs, that your case go to the OPP as opposed to the MPs?
That I do not. I don't remember, but I do not believe I did it on my own.
All right. Were you offered a medical visit to gather evidence after the attack?
Right after, I was interrogated by the MPs, which was over 3.5 hours. They drove me. They had another NIS officer drive me to for the SAA kit to the hospital. And 8 tips later revealed that the chain of command was more worried about media attention and about what was going on. And there's a whole bunch of other things that happened, but their concern wasn't me. It was what was going to come out of it.
So were you offered any legal representation or support officer? You were not offered any of this, okay. Were you provided with a transcript or recording of the interview that you gave? You said it was 3.5 hours?
Yes, it was. Well, I was there for over 3.5 hours, possibly 4 or 5 hours, because there were breaks in between, and before that, they explained me the whole process and everything. Sorry, I forgot the other part of your question. Go ahead.
Okay. Well, I want to go back to the last one because you shook your head, but we have to have it on the record. Did you have legal representation or a support or liaison officer provided or offered to you?
No, I got my own legal representation, I believe, after the case was dropped, because as soldiers, we all feel that they will take care of us. But I quickly found out that was not the case.
Was a member of the clergy brought in, or did you?
Oh, yes.
And what did the member of the clergy say to you?
Well, the Padres, to say it in a condensed form, the Padres, COC, mental health, all work together and they all go back to the chain of command, and it's all about exchange of information.
Okay, but what was his advice to you?
At first, he was trying to help me and evaluate my trauma. And then finally, he turned on me and he said things to me like some of his quotes were that I didn't write those down with me. I could hand them in later. But he basically threatened me that you're here to work and that, that the chain of command is very busy. And I can't remember his exact words, but they were hostile.
Was there any reference to unlimited liability?
Yes, thank you. He said something to that fact that you're an unlimited liability and that you came here to serve and that we could always put you back on PAT platoon if you don't like it. And I just felt very threatened, and I didn't understand why he took this completely different approach. And obviously that ended my communications with that padre, but they kept bringing in other padres as well.
To get you, so they didn't want you to pursue this. Okay. Were you resuming your training right after that, or in your same stream of training, or what happened instead?
No, as a matter of fact, as a weapons tech, I had asked to be placed on a French course because I am bilingual. And when they put me into the French engineering course, they came in and they said that, you're not qualified in French. And I said to them in French, mais je fais mes cours en français, je parle français, puis je viens de Québec. And
I said, I'm from Quebec, I speak French, there's no problem.
Pulling me out of the class in front of everybody. But finally, they let me stay in class, but I did have to pass written and spoken French afterwards.
And did you?
I started to. But then, I'm sorry, I think time was up.
No, it's okay. I don't want to interrupt. I just was going to go to the next witness, but by all means, finish your thought.
Okay. Sorry, we were saying, what was your last question?
So I wanted to know whether or not you just resumed your regular course of education, or were you required to do something else?
No, they kept telling me they're going to put me back on another course, but they said that they didn't have English courses. So I said, fine, put me on a French course. But they said, for the Francophones, because there's less people, it takes longer for them to be on course. And then I asked for an OJE back in Montreal, which they kept delaying me, and they said I'm delaying myself because now I have a lawyer. And then that's when they were throwing all the 1-800 numbers, and if you want to be reporting, then call here or do this or write memos. So it's just a whole bunch of hurdles that they try to put in front of you. And I was sitting, they actually told me to put apps in my phone to play games, which I usually don't, and to sit in a canteen and wait while the other people were in classes. And I just sat there and waited.
So I have to keep time, and I apologize for that. We do appreciate your service and being here and expressing something that's very sensitive. So I don't want to interrupt. We do have timelines. So Cheryl, thank you for your questions. I'm going to go now to the next member, Cheryl Raminato. You have 6 minutes.
Thank you very much, Mr. Chair. And through you, I'd like to thank the witnesses for being here, for your service, and for coming and sharing your stories. Everyone here is trying, and I believe you are too, to make sure that this doesn't happen to anyone else and that justice is served. So your testimony today is incredibly important for us to make sure we get this right. So I want to thank you for that. I want to start first with Ms. McDonald. You said a few things that piqued, that I'd like to follow up a little bit on. You mentioned in your testimony that the CAF that were using their rank, and what we've heard in previous testimony was the CAF shouldn't be investigating themselves. The independence is lacking. You mentioned you were never interviewed, that you ended up going to the civilian police and they told you to go back to the CAF. So could you elaborate a little bit about what your thoughts are in terms of C11 and how that could help provide some clarity, but also some independence. If you could elaborate a little bit.
So right now, the Canadian Armed Forces, which is struggling with a problem of conduct of its membership, they're investigating themselves, and they're using sexualized violence to control their subordinates or to establish power over colleagues. It's used as a tool of social control and power. The part where it's normal everyday behavior. This is what they do. This is how they behave. It needs to be separated, because what happens is that they start with human rights violations, and then they move into criminal code sexual violations. So the criminal code part needs to be removed from them so that there will be consequences for their conduct. There is no consequences for human right violations with the chain of command. So the part where we're looking at things where, the chain of command wants to use their military judicial system to maintain good order and discipline, they could start by addressing human right violations. But what we see from high-ranking members is they violate human rights, and then they get promoted and moved into another position where they have authority to address the hostile sexualized culture and keep going on with their bad behavior. So it needs to be removed so that there's a consequence.
Thank you for that. My next question is going to be for, and I want to say it correctly, Ms. Jez Barani. You mentioned that you didn't receive any supports in terms of what happened to you, that the person who assaulted you went on to continue their career in the Canadian Armed Forces, even though there had been a previous case you had mentioned. So there was a pattern of behavior here with this person. And when you reported, did they not take it seriously?
Thank you for your question. If I may. CAF was aware of a predator on base after the first victim, along with her witness, also making a complaint, and soon after, they sent him on training with us to Shiloh, after being told of abuse reports on that course. My COC was more worried about quotas he had to meet with HQ, as they tried to convince me they don't see the gravity of my rape, which was after the training. And during that time, there was 5 COC who sat around me. ATIP showed that the COC was more concerned, as I said earlier, with the media attention as well. The MIR and mental health were also there to extract the information. When I was in one of the meetings that I was ordered to, the words that they were using, and these are some quotes, that they accommodated me. There's no pleasure in keeping you in Borden. There's no one's holding a gun to your head. There's no policy for someone like you. We are bending over backwards for your situations, for your situation. Memos are not about you. It's a sales opportunity, a sales pitch for what you want. Finally, I asked them, what am I selling? And they were just trying to pressure me to sign things. And if I may go on, I could tell you about the NIS, that the investigator prevented the accused from admitting his guilt, even though he was a known predator and under investigation for another sexual assault. And as a matter of fact, he had to leave his interrogation about my case for the other sexual assault interrogation. It's in the file.
On that note, you all, sorry to interrupt you, but all of you mentioned something about reprisal, that there are probably many cases that don't get reported.
Right.
And we've heard that. We heard in previous testimony, probably even 80% of cases don't get reported. And when people do come forward and report it, there's retaliation, as you mentioned, Ms. Smith. There's sidelining of careers. You're pushed out. And what we're trying to do is, first of all, provide justice and supports to victims, prevent this from happening, but also to build back trust in the system. I have children serving in the Canadian Armed Forces, and when I hear stories like yours, I can imagine how other family members feel when their child decides or their family member says, I want to serve my country. Because out of fear that, will something happen to me, but worse, as you all mentioned, I'll be failed by the system. It's, as you mentioned, Ms. Van der Veer, almost re-victimized. The process of going through the reporting and the investigation is just as traumatic as the assault. With respect to this bill, is there something that you would like us would you like to recommend to us? And I probably don't have a ton of time, but if ever there's something you want to also submit to this committee as recommendations, I would urge you to do so through the clerk, because this is going to be very helpful for us. But I'd like to just open it up as well to Ms. Smith and Ms. Van der Veer, if there's anything you'd like to add.
For me, I would say that the ultimate prevention is accountability. Mm-hmm. There's so many movements where there's classes for new service members about boundaries and psychology and unlawful orders, but you can teach all you want, but if there are no consequences, if there's no real justice, if there are people in leadership who have gotten away with crimes, the culture is created. And I often say that we all learn in basic training. There's one thing every single military person I know knows, and all of their family members know, is don't walk on the grass. So why are human lives not as important as grass?
Thank you, Ms. Smith.
Thank you. Thank you.
Mr. Tremblay, you have up to 6 minutes.
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chair. Thank you to the witnesses for your testimony here today. Pardon me if I'm mispronouncing, but Madame Jasvareni, I'll start with you. I think we come from the same town originally. So your experience with the military police, and in fact, your testimony was very touching. Your experience with the military police, your experience shows that the military police accepted the chain of commands version before even speaking to you, if I've understood you correctly now, based on what you said. Is that correct? Thank you for the question. I didn't hear the last bit of what you said. If the military police, so your testimony indicates that the military police took the testimony, took the version provided by senior commanders rather than hearing, and before even hearing your own comments, correct? I'd like to read something. It's written in English, if that's okay.
After an ATIP, the CEO of the RCME school stated that the action taken on my sexual assault case was discussed with NIS to ensure that investigation was closed. Alors, comme vous voyez, il y avait la discussion.
So as you can see, there was a discussion between the chain of command and the military police. And you see this in the ATIPs, that this was discussed. And on that point, we're studying a bill here that has a lot of good intention behind it, but we are hearing from witnesses in order to strengthen it, to improve it. How do you think we can avoid this type of situation where here we are with your testimony, not even being heard before the decision is rendered on the case? Thank you for the question. I wrote something here. I'll read it.
Mr. McGinty stated there is no cover-up or criminal behavior. All I experienced was a cover-up and interference, which questions this. I was dismissed without warning with no AR signed on my behalf in 7 places. I asked to work in intelligence until 65, but my career vanished and I'm unemployed without an evac. Justice Arbor on page 33 said, in my view, the continued hostile environment and mistreatment of many female cadets in itself justifies an in-depth examination of the future of the military training. I ask Parliament to look at the details of my experience as there is an overlap with proof. Mr. Fowler's stating of not seeing an overlap. I had this overlap of JAG with NIS and COC, and my witness who was linked to my engineering school and later lost his life. And as I said, that what was discussed with COC and JAG, that the case was ensured that the investigation was closed. Me and my case were studied in person by JAG lawyers at a Timmy's 6 days after my rape and discussed on a civil shooting range between JAG, a club member, and a civilian lawyer. A warrant who dealt with both victims happened to be the Crown's witness, claiming he knew nothing of my case, is also a complete overlap. A known lawyer recommended by a support group called NIS, this is another lawyer, then lied about the information, and then he proceeded to threaten me, saying to be very careful and what I say and do from now on. Lawyers, some with CD titles, took my info and money and said it's a conflict, or they said it's a conflict of interest or unfamiliar with military law. Where do victims find lawyers as our documents disappear? CAF also seems to be using retired and active members to stifle victims. Some have spoken before your committee. The RMP's decision of insufficient proof was the reason given to NIS, even though the video interview of the accused showed his admission. The abuse of power, JAG ignoring the previous victim, his admission, my STD, and tampering with evidence is against the standards of a representative of our government. This is alarming and we need accountability. J'espère que ça vous a donné des réponses à votre question.
I hope that provided some answers to your questions. Yes, absolutely. But let's keep going. How much time do I have left, Chair? 2 minutes, okay. So in your case, we know that the review commission or the committee did not have access to the case information. Under C11, there's a transfer of jurisdiction. So the military police would not be investigating. It's transferred, but there's nothing preventing the military police from having access to the notes, to the decision in the past or currently. Should we amend C11 to make sure that there is automatic access to the relevant files? Thank you for your question.
Sorry.
To answer your question about military police, it doesn't change much because they would be the first on site. So in my case, there were a number of things that disappeared. That's the best way for me to explain it. I don't know how much time you still have, but if I can read.
I would suggest recommendations after my experience, which shows an overlap, and a new system may not be a full resolution. As 3 former justices, recommendations are underway or in spirit, as Professor McKenzie stated. As victims, we lost trust in the system. The government should also be mindful of the system where the DOJ is trying to redact another victim from my case, giving the image that I alone reported is only harming the public. Pushing for an inspector general sounds like a system is already in place with a JAG-like person, as mentioned in a previous meeting. I've had this JAG-like interference already, so I would like to see what is proposed. C11 still leaves MPs to be first on the scene with the evidence before police arrives. As Minister McGuinty mentioned, it will also not eliminate SA, only the evidence, as in my case, and we were worried about Section 70.1 and .2, I believe. But after C77, 66, and now 11, it is the duty of the government to make proper legislative changes and to re-examine human rights. More support groups are unnecessary. Please take care of the crimes and remove those that were influenced. Change of policies and personnel is needed with better recruitment, screening, and training, enhanced security, reduced retaliation with major accountability. Professor Mackenzie stated it is merely a piece of the puzzle, since she mentioned victims like myself who have gone through a long, arduous court process with the accused back on base working. If you put a system in place, as you noted, where victims were failed, past errors will be repeated. Angry families and groups may challenge you since SA and suicides are rising. With social media out of control, we need to keep the peace. As someone who worked in intelligence, you need to act as victims rise and justice unbalances. The root of the problem needs to be dealt with and preventative measures in place by removing those who covered up these crimes. Most victim services leaves victims rightfully believing that the system is bent in favor of protecting the accused and the system and not in aiding us protecting the public from harm, which Justice Arbour also referred to. And she also stated external input should be common thread throughout all CAF activities impacted by the issue of sexual misconduct. In my opinion, the overlap was evident, and the abuse of power by those above, especially on the young, is the reason my experience as an older rape victim is unique. SA and other criminal offenses of a sexual nature are now being referred to civilian authorities, yet my case clearly shows tampering to me, and it felt as a smokescreen to trap victims from further reporting, even with a known predator on base, trying to shame me in court and public. With the overlap I experienced, has a justice system dropped the scales of justice? J'espère que j'ai répondu à vos questions.
Merci.
I hope I answered your questions.
Appreciate your responses. I am sensitive to time, so I'm not going to cut anybody off, but I do ask everyone to try to be mindful of the time. Mr. Kibble, you have up to 5 minutes.
Chair, and thank you to the panel for your service, and I commend your courage for coming here and helping us work towards a solution specifically in C11, and I respect it's a very sensitive topic, so if you're uncomfortable to proceed with my questions, just please let me know, but I look forward to your answers. Ms. Smith, I appreciate you talked about accountability, and we've also heard from other people that have also said culture change is part of the solution. You said that you were in the U.S. military, correct?
Yes.
And have you served in the Canadian Forces?
No.
And are you familiar with the Canadian Forces justice system?
No, that's similar, but I've seen that there's less infrastructure for survivors than we have in the U.S.
Fair. Okay, so you do have some familiarity. Thank you. I just wanted to clarify as well, when we're using an acronyms, MP in your cases refers to military police and not members of parliament, just as we're going forward. And I appreciate that there's lots of acronyms that are used. Ms. Vanderveer, you said that you've worked with numerous survivors.
That is correct.
And so in your work with them, have you felt that those survivors or in your own experience as well, that people would want a choice between either a civilian or a military prosecution? Or
Absolutely. That's what I've heard, that they would like a choice, but there is a concern with going to the civilian courts, which I have mentioned in my testimony, is how are these judges trained? Because so many of them don't understand the complexities of the military. And it's, very challenging, when they're trying to understand, well, why would somebody go off with another uniformed member? Why could you just not walk away? You obviously can't walk away if you're aboard a ship after being raped. So these are the things that, how do we get the civilian courts to understand these complexities while trying to solve these, bring justice to these cases?
Thank you. And all of the witnesses have stated cover-ups of information or suppression of information. Do you feel that C11 should have specific regulations for the accountable transfer of evidence from military to civilian police?
Absolutely. And one of my concerns is that there would be such a delay, because we've seen that within the military system, that things move glacial speed sometimes in handing over documents. And, the delays are, there's always delays. And so, yes, it needs to be handed over quickly and efficiently to prevent, people from just hanging in limbo.
Thank you. And in your case, were you aware that, or maybe I'll open it for all the panel, that there was a choice between prosecuting these either through military or civilian?
Well, for my particular case, I am a class action member. I had no choice at the time that I served. We were not given the choice to even report without retaliation. So I cannot speak on that.
Thank you. And Ms. McDonald, you wanted to address that?
So I reported, first I was mandatorily, I had to report in through the military system. Everything was dealt with by the military. But whenever the government opened it up to reporting into the civilian system, I moved into the civilian system. And I also used the civilian system because the chain of command was refusing to write down allegations because they wanted to mark everything as sexual harassment from the beginning. So I gave my allegations to the RCMP and then did a statement with them. And then I was then interviewed by again, I gave another statement to the Canadian Forces National Investigative Services.
Okay, thank you.
So the issue with it was that the civilian police also relied on evidence gathered by the CFNFIS that had to do with like rape supportive attitudes regarding consent.
Right.
And civilian police need to be trained in terms of how to deal with that.
And I wanted to ask Ms. Vanderveer about that as well. You said that C-11 doesn't fix it, and you mentioned three things, including closure. But specifically on the legal aspect of it, what changes do you think would help fix it?
That's a challenging question.
But I respect your opinion, and because you've worked with so many survivors, you could probably provide us with some excellent insight.
I'm hoping I can. I mean, the hope is that, again, we can educate the civilian court systems on how to accept these survivors is the big thing. As to what that looks like, I really don't know, because I think back to, we're all aware of the Calgary judge who, had said to a sexual assault survivor to close your legs. So I do worry when I do hear those particular cases going into civilian courts. Are we going to have judges that are trained to deal with this? I'm sorry, what was the rest of it?
Thank you. I think I'm probably out of time, but I would like to add, you mentioned that some of you have some statements beyond what your opening statement was that you would wish to provide. And I'm sure that if you submit through the chair that he would accept those statements. Thank you very much for your honest answers.
Thank you. Ms. Lapointe, you have up to 5 minutes.
Ms. McDonald, I want to thank you for the depth and the clarity of your submission and for the strength it takes to walk through these experiences to ensure that no CAF member should ever have to face this. And I also want to express how very grateful to all of the witnesses we are for your courage and for your continued engagement with this process so future members may be better protected. So thank you for all of that. Ms. McDonald, Bill C-11 aims to ensure that sexual offense investigations are independent of the chain of command. When you first reported harassment and confinement, were any immediate protective measures put in place to separate you from the individuals involved or even to ensure your safety within the unit?
No. And the military police investigation verified that the unlawful confinement in terms of me being locked in a CCAN happened. But what they did was they then used that to send me for a medical examination to discredit me. And that, which was a human right violation, was supported by the military police officer who wrote the report.
Your submission describes a pattern where civilian police redirected you back to military police, and then the military police then deferred to your chain of command. So C-11 seeks to eliminate this kind of jurisdictional back and forth. If your sexual offense reports had gone directly and exclusively to civilian police from the outset, do you believe key evidence, timelines, and the quality of the investigation would have looked different?
Yes, and I wouldn't have been sexually assaulted as many times as I was. I was raped twice, and I had a breast grope in basic training, which was used to scare me for trying to report what was going on in basic training. So if I had been allowed access to outside authorities, they wouldn't have been allowed or permitted to use rape and sexual assault as a tool of control.
It's so difficult to hear this testimony, so I'm going to say thank you again for your courage and your strength to share these experiences with us.
I also wanted to mention that because none of my perpetrators or any of the human rights violators were ever disciplined, they've moved on to different careers in the public service. So now the doctor who conducted the mental health investigation works for the same detachment in Oromocto that did the civilian police investigation, which relied on information that was from the military, and that needs to be addressed, where it needs to be specialized investigators who understand the chain of command and are willing to do something about it. The civilian police officer didn't want to lay charges against my perpetrator, who is a high-ranking military member, because he said that it was a chain of command issue. During the CFNFIS investigation, military police officers deferred to the chain of command, which would then have been General Wayne Eyre, and he chose not to address the sexual assaults by this commanding officer. And then the military provost office blamed me for not re-reporting and asking for the military police, where I did. I asked for them through my chain of command whenever I was serving, and they refused to give me access to military police. They would send me back into the chain of command, where I was assigned a assisting officer who was a direct subordinate to one of the doctors who wanted to have me declared mentally unfit for service for complaining about the hostile sexualized culture. So it was all a setup, and they knew what they were doing, and they used the machinery and the mechanisms within the military judicial system to get away with sexualized violence and criminal sexual behavior.
So I know I don't have much time. One of the recurring concerns raised by survivors is the difficulty of simply having their allegations received, documented, and acted on consistently. Yes. Drawing on your experience across multiple reporting attempts, what do you see as the most important characteristics of a reporting environment that makes survivors feel safe, heard, and also believed?
So I experienced the military police screaming and yelling at me and telling me to stop trying to make a report. I was persistent because what happened, I had been a civilian and worked in the civilian system as a civilian social worker prior to enlisting. So I was absolutely shocked and flabbergasted by how this was allowed to occur. I actually even contacted retired Colonel Bruce McGregor and said I had allegations of sexual misconduct to report, hoping that he would put me into a fair system where I would be allowed to report the allegations. And what happened was a member of the military police called me up and screamed and yelled at me and told me to stop trying to make a report. The interesting thing about that is that the military Police Complaints Commission has verified that they actually documented that incident, which is a clear charter right violation because they're trying to make me scared and intimidated for reporting. But what needs to happen is you need to have professional people who are not going to scream and yell and try to intimidate the victim, and they're going to allow the victim to make their statement. And what happens with victims, like and myself, whenever I went in to make a statement or it's like you're being interrogated. So it's like you're being interrogated over and over and over again. And what the system is doing is wearing down the victims where they don't have support because the state is not with you. The whole idea that rape and sexual assault is a crime, it's not a crime if you're not going to enforce it. So we don't have equal benefit of the law because of how the system is set up to process the crimes.
Thank you. Mr. Savard-Tremblay, you have up 2.5 minutes.
Ma prochaine question,
My next question is for Madam Smith. In sections or clauses 20 or 2022, there's a change to the non-publication or the publication orders to protect victims. Do you think this is sufficient in the sense that it protects victims from being re-traumatized, specifically in cases where witnesses would like to testify anonymously or, let's say, share their experience with a therapist?
I believe that having protections of being able to report anonymously are huge for victims because over in the U.S., I believe it's about 70% of victims are retaliated against, and I think it is actually just 1% that actually get to a conviction. So with that knowledge, there's no incentive to really come forward, and any avenue that can be taken that insulates them and helps them understand that they will be believed and protected rather than attacked or re-traumatized through being interrogated repeatedly is super important.
And on that specific point of changing the non-publication orders, are you hearing the interpretation? Yeah. On this issue, specifically of those sections of the bill that reforms the non-publication orders, do you think that's a good idea? Is a step in the right direction?
Yes, having that there is essential to feeling free to speak. In my own assaults, there were numerous. I did not come forward because I had seen what had happened to other people. My mother was a service member as well, and when I called her to, say the words that no mother ever wants to hear, in her over 20 years of service at that time, she didn't know what to do or what to tell me, and she was an officer as well. So I think that having any kind of reinforcement where it keeps people safe and keeps them from feeling like there will be a target on their back or any means of, in my case, my car got vandalized. I was completely ostracized from officers' calls. I sat at a table once and everyone got up and moved, and everyone knew what was going on when no one should have known what was going on.
Thank you, Ms. Smith. Thank you. Mr. Anderson, you have it to 5 minutes.
Thank you very much. I'm going to preface this with some new information that may have come out yesterday or today. I don't know if you've seen a report by Benjamin Robach. He's the Ombudsman for victims of sexual violence, for victims of crime, rather. This was a 3,000-person study that he did about the civilian system. Using 3,000 people is a fairly robust sample, and it examines how victims of sexual violence are treated, including whether they are actually believed, and this is in the civilian system. I'll read one of the strongest statements he made in this preface of it. The harm is so well recognized that police officers and Crown attorneys regularly caution survivors against reporting or pursuing charges. The administration of justice is in open disrepute, Robach said in his foreword. And included among the statistics that he presented, 93% of the complainants said that they feared police wouldn't believe them. Of a random sample of 1,000 self-reported violations, 51% reported the crime, and of that 500, only 102 cases went to trial, resulting in 70 convictions. 268 cases have been stayed since the Jordan decision. Sexual assault is the most likely to be stayed or withdrawn. Now, I point those statistics out because we had a previous witness, Lieutenant Colonel Rory Fowler, who said that what has happened, and I am so sorry for your experiences, but his point is that what has happened is a failure of leadership within the CAF rather than a failure of process. We had another previous previous witness who suggested that the answer to this problem is a cultural thing in the military, and that what needs to happen is a culture change before anything ever gets to the criminal level. Ms. Vandermeer, can you comment on that?
I'm sorry, can you say your question again, please?
Sure. I'd like you to comment on the thesis that the answer to the problem, there's no perfect answer, but to mitigate the circumstances is to change the culture within the CAF so that it never gets to a criminal, to sort of halt the process before it ever gets to a criminal level.
Great. Thank you for repeating that for me. Yes, I completely agree with you. I have spoken with survivors, and even in my own experience, survivors can get over the rapes. I have heard that numerous times. If the system would have just handled their cases better, if they would have believed them, would have, done the due process in a timely manner, they said they can get over this. But because, they're not believed, because they're questioned, what were you wearing? What did you do to cause yourself this issue? And you shouldn't have to go through that. So yes, it does need to start culturally. We need to start believing survivors. We need to start believing the men and the women, and not brushing it off as, well, what's the matter? Can't you take a joke? Or, it's just hazing, or whatever the narrative may be. We need to believe them, period. And then the system needs to, move forward with charges or whatever that looks like.
Yeah, I'm previous military. You're all previous military as well. What do you think of the argument that it is easier to change a culture, to make culture change within a chain of command in the military than it is in the civilian world, in terms of the legal system? Ms. Jesperny?
Yes. For me, culture change does not address all the issues, especially recruiting. There's alcohol and drugs on the base. There is improper security, and the people need proper instructions. Culture doesn't change. Base procedures and proper morals do. For me, these were just smokescreen words. Confidence and trust words used at committee is a psyops tactic to force the public into thinking that changes are being made. What type of culture keeps rapists together on a base with victims? How is that culture?
With respect, would it not be true that is the culture, that is the culture that needs to change?
Well, for me, they need to implement more instructions and talk to people and take away or monitor what is happening, because all these young kids who are leaving their home for the first time to serve and they're given a good paycheck, it's the first time they're away from home. I mean, as an older individual, I've never seen that much drugs and alcohol in my life. So if I just would like to finish just that CAF must recognize that culture change, gender issues, transparencies, and these modern terms that they're using, it does not align with reporting a crime or being a victim. To me, it's just a word that they're using just to hide everything away. These terms make soldiers uneasy and unafraid to speak or joke, just like on forms a he or she or other. And I saw this personally, and I witnessed this. And also what happened in the past, like it turned into ridicule. For example, hop on her, which is the op on her. That's what they were calling it. This just causes more retaliation, as I saw with my coworkers in the office. Our military needs to concentrate on protecting our country with any gender and culture that is willing to protect our borders and be trained appropriately and work on their military ethos. Instructors on Fridays ended our engineering class by saying, don't get killed, don't get caught, and don't become a statistic. We were told to call a number, I believe for MPs. Was it to cover up from the civilian system? I mean, these are things that we see happening continually, and what I witnessed as an older individual, it's quite shocking. And as you said that you have your own children serving, it is quite concerning. So I believe we need to go to the root of the problems and look at all of these individually.
Thank you very much.
Thank you. Mr. Merlot, you have up to 5 minutes.
Thank you, Chair. And first off, I too want to echo my colleagues in thanking you all for your powerful and impactful, and I'm sure in some cases painful, recollections and testimony here today. I'd like to first start with Ms. McDonald. And we'd heard previous testimony in these hearings that choice is important for the survivor or the complainant or the victim, and it's been the terminology has been batted around, and even the suggestion that lower level or minor cases could be heard in the military system, and then we just heard today that there's a suggestion that the state of the civilian court is in such a shambles as it deals with these sorts of incidences to why bother reporting, and this seems to be a common theme, unfortunately. Can you please give me your take on some of those suggestions that the choice is important?
So it may be true that it is true that the civilian system is in a state of disrepair, but the issue of having a choice, the issue is having skillful administrators of the law responding to the victim and giving equal access to justice. So if it's a choice between, a choice doesn't help. Like, it should be the system, the government of Canada is responsible for setting up the system. So it needs to be that the actors of the system behave skillfully. What we see whenever we leave it with the military, it may be a failure of leadership, but the administrative safeguards are not in place to prevent the CAF leadership from engaging in human rights violations and sexual violence. The tools of governance are not present in the administrative system. So we need to provide those tools. And if a Canadian solution is to move it to the civilian system, which it seems to be, this is our Canadian solution, which our 3 Supreme Court justices who are experts of the deliverance of justice say, then this is what we need to do.
So further to your expertise then, what long-term impacts have you observed when survivors cannot access timely or appropriate care, and how can this legislation better address that?
So as a clinical social worker and a champion of the class action lawsuit at the beginning in terms of trying to convince other women to come forward, and serving other women as a clinical social worker and trying to help them to get access to resources and justice after their abuse, what's happening is horrific. It has more mental health impacts than the actual sexual assault themselves. They're more traumatized by the system that is being put in place. It's horrific what's happening, and women's rights and sexual abuse victims' rights matter just as much as those accused of engaging in sexualized violence, and we need to have it set up where it supports them.
Thank you. Do I still have time, Chair? Thank you. And further to that, and to the issue of coming forward, as you had mentioned, I'd like to ask Ms. Jasbareni, based on your experience as a member of the CAF, what were the biggest barriers that prevented survivors from coming forward when the abuse, and especially in your case, can you just, can I just ask you before you answer that, when was your assault?
It was in 2018.
2018, okay, yes. Thank you. Sorry, I didn't mean to distract you from the question.
No, that's okay. So your question is, like, what prevented it?
What in your experience, what were the most impactful barriers that prevented you or others that you, in your estimation, from coming forward?
Thank you for the question. First of all, when you're in the military, we already know that making a report, you are taking a huge chance with your career. And for me personally, if you're asking me personally, being an older individual, serving in the military and having a career, of course, I didn't want to throw my career away. And it was already being hard being among young soldiers as somebody so much older. And I mean, I was basically the age of the chain of command or the CO. So that's one of the biggest hurdles. And also what I experienced was a lot of gossip. And to answer part of the other question earlier, my assailant continued his courses. So you know that they will have no hurdles, but when you report, you have to go through all this process. You know, you're inundated with all these 1-800 numbers, acronyms, and all kinds of things. And for example, one time my sergeant came to me, I believe it was like 64 pages possibly, on how to write a memo. Because in the military, because my memo kept being refused, and you had to indent it and do the right characters and everything. So you're inundated with all these hurdles that are just a waste of time. And, you know, I was ready to serve, but I was there sitting in a cafeteria waiting and nothing to do.
Thank you for your testimony. Mr. Bazan, you have to 5 minutes.
Thank you, Mr. Chair. Witnesses for being here, and I know how incredible difficult this is, and especially when you look at that you guys all signed up to serve your country, and the very institution that you wanted to be a part of is the ones that you know, instead of going out there to fight the adversary, you have to fight off the very men and organizations that were supposed to be your you know, combat in arms. They're supposed to be your friends, your colleagues, and they turned out to be your adversaries. So just again, just if you guys can all just quickly tell me what year that your sexual assaults took place, and just the years, just so I have it clear in my mind as well.
Me?
Each one, just.
January 2015, March 2015, January 2016.
Wow.
My date, I believe, was May 13, 2018, and I reported right away, pretty much.
For mine, it actually started in recruiting in 89, 90, and 91, and 92, and 93.
Oh, man. This was.
The first one actually happened while I was a military dependent with a doctor, so that was 2001. I was 12. And then again in 2012, as a senior in college in ROTC, been repeatedly 2013, 14, 15, and 17, and I got out of the military in 15. And then there was a very close one at a VA hospital in 2022, at the end of 2022.
Well, that's terrible. No, I don't even know how to respond to that. That was that systemic. Now all of you are aware of the Madam Justice and Madam Fish and the Madam Madam Justice Deschamps, Madam Justice Arbor, and the Madam Justice or Mr. Justice Fish reports. Were any of you at all asked for testimony or were interviewed by any of those justices?
Arbor.
Arbor, I should say, yes.
Yeah.
She interviewed you?
Yes.
Okay. Did any of the other were interviewed? No. Okay. And I maintain, Mr. Chair, that we should have Justices Deschamps and Arbor up here at committee so that we can talk about their previous reports and if they've had any extra recommendations they wish to make at this point in time. Ms. Vanderveer, you talked about whether or not you actually said that C-11 is going to create more bureaucratic ping pong. I like that. Do you see that Bill C-11 is just the attempt by CAF leadership to pass the buck and now push this all off onto the provincial civilian system, using provincial courts and provincial prosecutors, and then can just wash their hands of it?
Yes, that's how I feel, and the people that I've spoken with and the people that I work with, that they feel it's shifting the blame. And many are not against the civilian court system, but again, how do we educate these judges to take on these cases?
So as we just heard from Mr. Anderson, that Ombudsman Roebuck just did his report. 3,000 cases were looked at. Saw that as he said, the police officer and crown attorneys regularly caution survivors against reporting. You had the Jordan framework as laid out by the Supreme Court of Canada. That justice delayed is justice denied, and if you can't do it within 24 months, it's out. So the accused are walking away scot-free. So my question to you is that, and you mentioned that justices provincially aren't trained about how the military operate and how accused and victims may end up on the same training exercise as long as they're still on base. How can we deal with the lack of understanding of how the Canadian Armed Forces work when the judges, the prosecutors, the defenders may not fully understand and appreciate the way the Canadian Armed Forces actually operate?
To shift the civilian courts, there needs to be some sort of education for the judges, for the prosecutors. They just can't compare it to civilian sexual assaults and misconduct, because our world is very different to the civilian world, which we all know that.
So Ms. Jasbrini, you had mentioned that you're concerned about 70.1 and 70.2 as drafted in Bill C-11. And if you go down there's also, 70.24, where there is the transfer of evidence from military, police, National Investigative Service to civilian authorities, but there's no timeline in there. Do you believe that still the chain of command could interfere with the transfer of evidence to the civilian court, and that unreasonable delays may cause the Jordan framework to be kicked in and cases stayed or thrown out?
Thank you for your question. Yes, I believe that the chain of command, as in my case, caused even more delays. And like I said, my file would get thinner and thinner. I would also like to add to that, because the SRC was spoken a lot about, and I believe the last time it was called the Cadillac for victims. Well, for me, that Cadillac crashed. They told me to call the ombudsman, and then the ombudsman said that he only deals with admin issues, and he refunded my ATIP. Then I was told to contact the CCMS, and after 2 long meetings, he just told me good luck. The other thing I would like to touch upon is the data collection, because most of the hurdles that they cause with victims, it's only to extract information. The reason that the information is extracted is for their own benefit. So that's all that I experience. I can't speak for other people, but I'm speaking on my behalf as well.
Thank you, Ms.
With my case, what was...
I'm going to give Mr. Watchorn some time. He may continue with that testimony, Mr. Watchorn.
Ouais, merci, Monsieur le Président.
Thank you, Mr. Chair. And thank you to all of you for being here this morning to testify to your experiences. I feel it is very courageous of you to come here and help us with this bill, Bill C-11, to improve it. Madam Jasbrini, if you wanted to complete what you were saying, go ahead. Thank you for that. I just wanted to say this.
English, 5 letters were written to me, and they said that they were unable to obtain information and they would have to apply to federal court since their work was compromised by CAF, even though the defense minister signed off on the MPCC questioning why the accused was not charged. So we have all these hurdles if you put this into place. That's what I'm trying to explain exactly from my story, what they were. So go ahead if you had a question.
C'est très gentil. Écoutez.
Okay. So what we're talking about today seems to be an issue of trust. You need to have trust in the process that you're going to be believed too, that the process we have in place will mean your case will be treated appropriately based on what we're hearing about C11 and Justice Arbor stated this. There's a crisis of confidence or trust in the CAF as to the ways in which sexual assault are addressed, misconduct are addressed. I'll start with Madam McDonald. Do you have more trust in a system that is a civilian-based system or versus the military system? Because what we've often heard is this. When you report something in the military system, you have fears about your career and concerns about your future. Madam McDonald, can you start?
So the big issue that I see where it's like is that the military system uses the resources that it has within the judicial system to punish the victim. And by transferring it away from them, then that removes a tool that they have to interrogate, harass, and belittle you for reporting or telling the truth. So yes, the civilian system has issues. The military system has issues. And I see it very difficult in terms of fixing the system where we see the independence of the actors isn't there. And it's a cultural issue where they say military police was supposed to be separated during the Somalia affair. Well, that didn't happen. So I see it as I think that it needs to be transferred because it needs to remove the ability to harm victims.
Madame Jasperani, la même question.
Same question from Madame Jasperani. Thank you for the question. Like Professor McKenzie was saying, it's just one piece of the puzzle. There are many things that need to be done differently.
I'd like to read that General Carignan stated that CAF will follow cases and make sure our careers will be intact. While CAF followed my story, as I see in my ATIPs, and my career disappeared, and I was released with no VAC, but they kept the predator employed among the soldiers. For over a year, I didn't receive my DND pension because my file was lost. I received a letter months after my release stating I was disabled and unfit for work and should have been released as such, but they released me using my age instead, stating the decision could not be changed. Other avenues were mentioned, which I tried as well, but were denied. Most officials did not walk in our boots, so it's essential for victims to be part of the decision-making to show you where the system really is lacking. Gatekeepers are taking and giving away our information. Hardworking military military are stifled within CAF by those who mishandle things, create corruption, and are rewarded and promoted. When my career was held back as an example, I told my master corporal, I don't feel trained. And he replied, I would have helped more if I didn't get written up for trying. The cycle needs to stop because it doesn't equate with military ethos. I also wanted to add to that that for victims like myself, we have lost a lot of trust in the system. So we need to, I guess, see what will be proposed. And the trust is going to be a long-term process.
Thank you. Madame Vanderveer, peut-être juste pour faire une...
Madame Vanderveer, could you answer the same question? But I mean, we heard what you said about the fact that you fear that the civilian justice system may not be able to fully understand the reality at the CAF. I would submit to you that there are courts that are set up, for instance, in Quebec now, specific dedicated courts for sex assault cases. So those judges, the judiciary, the Crown are trained to focus on these specific cases. Do you think that would be a good idea? Do you think it'd be advantageous to send these kinds of cases before these types of specialized courts?
Yes, I think it would be in the best interest to send survivors to courts that are specifically trained to deal with sexual assault and sexual misconduct. And then to answer your question over a lack of trust, the women that I mostly work with, by the time they get to me, they have zero trust in the military system. They have zero trust in VAC, in, Veterans Affairs. They even, trying to get them to an OSI clinic, they're not believed. And I had one particular woman, all we had to say was that we believe you. She cried in our office for 3 hours because that was the first time someone had actually believed her. And she had been out of the military for about 12 years, and she had never heard that before in her life. So it's very hard to gain the trust of people to say, can you put in a back claim? Can we, take you to peer support? What is it you need? Like, just even trying to present them a quilt of valor. They just don't even think that they're worthy of that because the trust has been broken within the system. And again, it's hard because you can't get them to trust the civilian system either at that point because they have just been so beaten down by the systems.
Thank you. Thank you both. Monsieur Savard-Tremblay, you have 2.5 minutes.
Madam McDonald, you're a social worker, if I understand correctly. That's at least you have a degree in this field. If anyone were to understand mental health issues within all spheres of this work, you get it. You also shared a concern that was often a factor used to harm victims. People would be sort of cast aside because they'd be considered with mental health issues. So their testimony would be faulty, influenced by false perceptions. What do we do with that? Knowing that it is true that mental health issues exist. It's well-founded, and you're in a better position than most to address that. But how could we avoid having that be used as an excuse?
So I suffer with post-traumatic stress disorder from what happened to me. And I am a clinical social worker who continues to work part-time and treat mental health issues such as PTSD. So what we need to do is label whenever the person is trying to say, oh, you have mental health issues because you're having a response where you're telling me to stop, or you're crying because I just touched you inappropriately. We need to label that for what it is and say that is a diversion tactic. That's actually a human right violation because you're not allowed to discriminate against me because I'm crying or whatever. You need to accommodate me and go from there.
Donc avec ça, parce que là,
So based on that, here we're looking at legislation that would seek to improve things for victims and, of course, provide more recourse to victims. That framework you were referring to, how would that be articulated within legislation?
I think that there needs to be more training for people who work within the legal system. So with people who are supposed to be facilitating the legal system, there needs to be more training for police officers and for lawyers so they understand what trauma-informed means. What that means is that they're able to question victims. Like, you can get answers from victims and you can get evidence from humans without using hardcore interrogation tactics. So what needs to happen is there needs to be more training, and perhaps you can come up with a clever way. I think that you have to input that through policy.
donc ça rejoint un petit peu la question de mon...
I think it gets back to my colleague's question about having specialized courts or resources.
That is what we need. We need specialized courts and we need specialized investigators who are separated from the chain of command.
Vous vouliez ajouter quelque chose?
You wanted to add something? Microphone? I myself have gone before the courts based on my experience. I'd like to raise this. As a victim,
in French, it's called VWAP and ILA, and they give us coupons for court. These were unhelpful, and I have a lot of evidence on this, that contacting these lawyers who are already working on their own cases, they were overloaded, and sometimes I waited over a month with no results at all. And especially using coupons as a victim is very demeaning. And not just that, but when I went to court, they were young women who were immature, and they were representing the system, and they were trying to help me. I mean, we need better system in court. And also I found out that when I was in court that the video cameras weren't working and the police, from what I believe and what I remember, were not armed. So if they're, victims need to feel a lot more security and safety. And as for the justice system, I'm not a lawyer, but I believe that there needs to be a lot of things implemented as well because of what happened through my case.
Thank you. Mr. Bazan, you have the 5 minutes.
Just to continue on with kind of that line of questioning about making sure the supports are there for the victims. And is there, in your mind, then a need to ensure that, that Military Defense Council, military defense prosecutors are allowed to go with the victims and the accused in the justice system to argue the cases in civilian court rather than using civilian prosecutors or civilian lawyers who are, as Ms. Jasperini just said, aren't readily available or educated, as Ms. Vanderveer has stated it as well.
There needs to be a separation. So right now what you'll have is the people who are working on the defense of the accused and the protection of the victim sitting beside each other in the desks, and there's in the same room. There needs to be more the process needs to be fixed where there's a separation so that you have it where there's not those inherent conflicts of interest that are there. And right now, victims don't get as much government support as the accused gets, where the accused are getting a military defense lawyer. And it also trickles into the Department of Justice, where the Department of Justice, whenever these cases are moving out into the civilian system, a victim has to go against the Department of Justice lawyers who are trained litigators, and you're a victim struggling with post-traumatic stress disorder with a limited budget. You don't have the budget of the Department of Justice. So that has to be looked at as well, where we have it where victims don't get the same support, and whenever it moves into the civilian system, they're re-victimized moving into the Department of Justice outside the military system as well as inside the military system.
Thank you. Anyone else want to comment on that? Ms. Jasperini?
Yes, thank you. I just wanted to add to that, as I read earlier, and this is a great concern, that as a victim, I can't go into a lot of detail, but I've been through more than one lawyers. And it is very difficult for victims to find lawyers. And a lot of the CD-titled lawyers also do not take our cases. And
Okay,
all they say it's
just on the Bill C-11 actually provides in clause 70.3, it says that nothing in 70.1 prevents an officer or non-commissioned member from initiating or conducting a private prosecution in relation to offense referred to in any of the paragraphs that fall underneath the criminal code. So is that even affordable for anyone?
Not attainable. It's not affordable if you're the victim.
It's a nothing burger within the act itself. And okay, thank you for that. You all have talked about trust. So in this scenario now, everything is getting transferred to the civilian courts. We aren't sure yet because all the memorandums of understanding are not in place yet with the provincial governments or with municipal and or provincial police services. The question becomes then, what happens with the accused? Right now, if they're charged, as you're all saying, nothing seems to be happening with the accused, but is it better or worse if they're charged, convicted, and then maybe even jail through the civilian system? Do you believe that those individuals should also get court-martialed? And does this bill indicate that anything will happen to them under the military justice system, even though they've been found guilty in the civilian courts?
I think that they should be court-martialed underneath the National Defense Act, because if you're engaging in human rights violations and then you're committing sexual assaults, you're also violating good order and discipline and different clauses within the National Defense Act. So they should be also prosecuted underneath the National Defense Act, but it shouldn't be left for them to be prosecuted for like the criminal code. That should go to the. Like they're very good at dealing, aren't they good at dealing with being drunk and drunk driving? Like they could prosecute that, but why don't we leave sexual assault for specialized courts?
Ms. Vanderveer, your opinion on that? Because we don't see anything in here on how those that were accused and then convicted actually face any military charges at all, other than because it's one or the other now. It's not. There's no longer a choice.
Right. I do agree, again, same with Ms. McDonald, that yes, they should be put through a court-martial as well, because too many times we see it, again, as we've said here this morning, that the perpetrators, get away with these acts. So we do need to hold them accountable.
So as we heard previously at committee, we also heard about this issue of gray zones that may not fall underneath something that is sexual misconduct, but doesn't necessarily violate the criminal code definition of sexual offenses. How do we handle those?
Again, like we've said here, I've heard it say too. Like again, the lesser charges I think should be handled at like the military level, because again, the civilian courts, they're overloaded. They can't deal with a minor sexual misconduct. So I think there needs to be like, both. How do we implement both type of thing? Because again, we don't want to overload the civilian court system, but we do want to see that there is justice and that people are held accountable for their actions.
Thank you. Thank you, Mr. Bazan. Mr. Ramanado, you have up to 5 minutes, and then we'll be wrapping up.
Thank you, Mr. Chair. I want to go to a different area in terms of a recommendation that we received from Professor McKenzie, who was here at committee. She had made a recommendation in terms of data collection. She recommended that we don't have good data on where assaults are happening, the outcomes of justices and cases, and that we need to have better data. She also mentioned that New Zealand, the U.S., and other jurisdictions actually have, she said, I think it was the gold standard in terms of data and processes. And while it does not show a decrease in assaults, it at least shows us where they're happening, where we need to provide resources. Ms. Smith, the fact that you're here with us today, I'd like to get your feedback on that. Would you have recommendations for us here in Canada in terms of some of the processes or supports that are in place with our U.S. allies in terms of these kind of cases? If you have some recommendations or comments for us.
Is that in finding out where they're happening?
Exactly. She mentioned, that we need to collect this kind of information. So I'm not sure how the United States is doing that. If you could elaborate.
That comes as a part of the reporting process. There's surveys done every year. I think the RAND Corporation just did one recently where they determined that false allegations are minuscule, where it's 2024 it was only 1%, and then between 2014 and 2023 it was 1 to 3%. Wow. But the overall attitude is that victims are lying still. And unfortunately, we've been having hot spots, so to speak, where this is happening frequently, like Fort Hood. That's where Vanessa Guillen was killed. And I think the story just broke last week where there was an Army doctor that was taking videos of patients, and he'd been reported multiple times. And it finally just hit headlines, but it had been going on for years. There's now a hotline for victims to call and report what happened to them. But it's taking into consideration that many people in leadership have done this, and their attitude toward it is that it's not serious. So in answer to a previous question, my solution has always been accountability, but it needs to be not just the perpetrator. the leadership involved where there is a climate in an office where it's okay for these things to happen. The supervisors, everybody within that chain of command has to go.
On that point, I agree. There should be an absolute zero tolerance. Absolutely. And part of C11 includes recommendations for a probationary period. You all mentioned instances where, sexual harassment, inappropriate comments, so on happening, and these things progress. If we are able to identify bad behavior very early in someone's career, deal with it immediately with a zero tolerance policy to prevent and to also send a very clear signal that this is not acceptable. I don't care who you are in the Canadian Armed Forces or what rank you hold, that if you do this bad behavior, but also allow it to continue even though you're aware of it. As you said, we've all said reportings were happening and things were not being taken seriously. Do you think that having that probationary period will also allow us to weed out people who should absolutely not be serving in the Canadian Armed Forces? And I see Ms. McDonald's hand is up.
So we have a problem where the people who have grown up within the culture of the Canadian Armed Forces, where it was appropriate to use your D&D email account to create an Ashley Madison account, or it was appropriate to use your work cell phone to look for sexual targets in the community that you were posted in away from your family.
Wow.
These people are in the chain of command, and they have the attitude that this is okay, and we're entitled to this type of behavior, and this is all right. So the problem I see it is that getting is having that discipline reestablished within the chain of command where it's not there, and that we have it where it benefited. Women were used as shields within the chain of command to shield men who were behaving badly from legal consequences. So as my colleague had mentioned beside me, where players in the chain of command went along and did nothing and supported the perpetrators of sexualized violence, we have an issue where we need to have some sort of an evaluation method to address their behavior. Some of them probably would not have gone along with the hostile sexualized culture if it didn't benefit them. Because we see where they moved up in their careers and they're working in different government offices now. And anybody who reported maybe is on like long-term disability benefits and not able to earn a career living in Canada. So there's that issue that we have there. That's a barrier.
Thank you. I think I'm out of time. Thank you so much.
Thank you all for participating, sharing your stories, being open with us. We know how difficult this is. We recognize that human rights prevails, and it should override everything else that's being taken place. And your testimonies and your stories reinforces the need for more than just cultural training, but real policy changes for us to prevail over this very sensitive and delicate issue. I was going to, do we need to, can I cancel? Yeah. Do you need to talk now? Yes, sir.
So I just want to thank our witnesses. I just ask that they, any further comments or recommendations you want to make on Bill C-11, please send those recommendations in. The sooner the better in writing to the clerk. And I move that the meeting remain in public for consideration of committee business.
Are you okay to remain in public? I was going to ask the witnesses to leave and to suspend into in camera, but you wish to have this in public?
Public, it's quicker. But the witnesses are dismissed.
Yes, you may go. Thank you again for being here today.
You got a motion? You have a motion on the floor.
Yes. We need to. Do we need to vote on this motion, Sherry?
Yep.
No. I think we have a motion on the floor.
We have to vote.
We have to vote on this motion. All those in favor of maintaining the meeting in public versus having it in. Okay. Oh, that's fair. Okay.
Do you want to suspend for a minute or two just to allow the witnesses to leave?
I'll suspend for a moment just so the witnesses can leave.